When can school officials be legally responsible for school shootings? We've often said, don't do nothing on this show. How much, not nothing, does the law require teachers and educators to do in the face of potential threats to school safety? Jamie, before we get too far into the heavy stuff, what do you think of my new hat?
That's a Chalk and Gavel hat. That's so cool. We have merch.
It's the dad hat from our new merch line on chalkandgavel.com. With the mustache, the dad hat, and I'm also wearing New Balances. This is the most this is the most dad energy I think I've ever felt. And I have 3 kids.
You're wearing New Balances. That's funny.
I am. They're not white. They're great. They're a tasteful, Do
you have your socks pulled up to your knees?
They're at least up to my thighs, right?
You wearing cargo shorts down there in Florida right now?
No, it's actually cold here.
Cargo pants?
No, normal amount of pockets.
No. Do you have like a fanny pack on or something?
Not on me.
Get your dad hat today at chalkandgavel.com, everybody. And there's lots of other merch there. We have coffee mugs, which are really cute.
Shirts,
can I
have my candy items. Now coffee mug?
We've got
document journals.
Oh, the document notebook. That's a great gift. So
it is.
Yeah. Mouse pads, because people still use those, right?
Right. The don't do nothing mouse pad.
Yeah. Anyway, lots of cool stuff on chalkandgavel.com. Check it out, everybody. All right. So listen, as it was probably obvious from Chris's opening questions, we're going to talk about one of the heavier topics today. So we're going to talk about school shootings and the law. I'll give my little intro later. So let's just not waste any time. We'll just jump right into it. Okay. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education, one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Welcome back, everyone. First, don't forget to rate, review Chalk and Gavel. If you're checking us out on YouTube, please give the video a thumbs up. We have a new website. We've talked about that a bunch. Check out chalkandgavel.com. It looks beautiful and professional because we are professionals. You can sign up for our newsletter there and get more information about the show. You can find our teaching guide. You can also find some ways to support the show. Your support means the absolute world to us, and it makes this show possible. And as we mentioned at the top, you can find new merch there. Polos, t-shirts, sweaters, this beautiful Chalk and Gavel hat. Pretty much anything you could want with our logo or any of the silly things we say on this show, you can find it all there. And with that, Jamie, I think you have our Bellringer.
Yes, I do have the Bellringer today. So we're going to stick to the same general topic for today's Bellringer and our main case. But before we get into those details, we just want to take a moment to acknowledge the weight of what we're going to talk about today. Okay, so these cases explore a legal landscape that is both incredibly important and undeniably painful. The question of liability in the aftermath of school shootings. So, between the Columbine tragedy in 1999 and 2024, there have been more than 400 school shootings, exposing over 370,000 U.S. students to these horrors. We can all recall many of those, like Sandy Hook, Parkland, Uvalde, but there are so many others that haven't entered the national spotlight, but still weigh so heavily on thousands of students, educators, families, and communities. These aren't easy conversations. We're dealing with devastating loss, with communities forever changed and questions that don't have easy solutions. Many simply don't have a conceptual understanding of how all this actually looks in schools now and what these experiences are for students and teachers. Because most of us in this country just don't know what it's like to go through childhood with code red drills and active shooter lockdowns. We don't know what it's like to grow up being taught when to run, hide, or fight in schools, right?
Yeah, because 99, I think I was only in 6th or 7th grade.
I was in college.
Oh,
Yeah. Like, I went through my entire schooling experience never even thinking about this.
Right. Yeah, because Columbine, that 1999 is kind of the
pivot
start of
point.
it, because it's
No.
always been an issue, but like where we've really kind of,
Yeah.
it's become a prevalent thing in schools.
Right. Exactly.
Right.
So listen, one loss is one loss too many. It's important to remember that our schools are still very safe spaces. They're
Some
filled
of the
with
safest places that children will ever be.
Exactly. These schools are filled with passionate, dedicated adults who want nothing more than to protect and nurture all of the lives in their presence. But our reality is what it is. And all of this stuff is making its way through the courts, and we're going to try to talk about a few of those cases today. So in the aftermath of these tragedies, what does accountability look like? What obligations do schools, parents, law enforcement have? How does the legal system play into all of this? And that's what we're going to talk about today. So we're going to attempt to approach this conversation with compassion and humility, recognizing that the law is only one piece of a complex story in our society right now, right? And it's an important piece, though. It's one that can heavily influence how we shape policy, how we seek justice, and how we protect our kids and our schools in the future. So, with that being said, let's get into it.
Let's get into it. Well said.
Thank you, sir. Thank you. Okay, our bell ringer. Our main case today discusses the question of whether or not students' substantive due process rights were violated by the actions of school personnel leading up to a school shooting in Michigan. But our bell ringer centers on a different legal question following the shooting of the teacher in Virginia. I think many of you probably remember the news from a few years ago. There was a teacher, Abby Zwerner, who was shot by one of her 6-year-old students.
Oh, I remember that.
Right? And this was massive news at the time,
Right.
because,
Unheard of.
it was, yes, a student that young. Most of our school shootings have involved older students.
Right.
So this was a big event, a few years ago. They're all big events, but this one was unique because of the age of the student involved. Now, Abby survived. She spent weeks in the hospital. She required multiple surgeries. I think she still even has the bullet lodged in her chest. And I think it narrowly missed her heart.
Ooh.
So it was a big deal, but she survived, and she sued the district. She sued the superintendent, the principal, the assistant principal, basically for ignoring signs that the student may have had a gun.
Okay.
And a judge dismissed the case against the superintendent and the principal, but let the case move forward against the AP. And at the time of this recording, just last week, a jury found that the AP was negligent and awarded Abby $10 million.
Wow.
Yeah, that's
okay.
crazy.
Right.
Pretty. Now, I think it's important to kind of throw this out there right now. All of this legal posturing around school shootings, it's pretty new. It's
very new. Yes.
Right? These cases are pretty much the only cases that are dealing with these issues right now. And that's one of the reasons why they're potentially going to have an impact on all of this stuff moving forward. Right?
Right. Yeah, because it's going to shape future practice, right?
Exactly.
Yeah.
So essentially what happened in this particular case, students informed a reading specialist, I think, that the 6-year-old might have had a gun. The AP was then notified, but didn't, at least according to the court, didn't sufficiently heed that warning.
Right.
And the child had just returned from a suspension after having broken or slammed or done something to Abby's phone. Like, so there was an issue, and then the kid was suspended for doing something. And on the day the kid returned, that's when the kid shot the teacher.
Right. Yeah.
So anyway, that was the decision that came out last week. The assistant principal here still faces multiple criminal charges that center on essentially on child neglect. And my understanding is those charges are potential felony charges, which means I think there's like 7 or 8 charges, and each one of them carries a potential like up to 5 years in prison. So like this could be very, very bad for this assistant principal.
Right.
Right.
Right. And because the allegations are, and I guess at this point they're not allegations because the jury already found the AP
negligent
liable, right?
Yeah.
But like basically 2 or 3 teachers told this AP that this student had a gun. Someone said that another student had seen the gun. Like it wasn't just a like, oh, on a whim, like I think this student might have a weapon. It was like 4 or 5 people, like, and so that's one of the things that these cases kind of really get at is like there's a really high bar for a lot of these cases for a lot of different reasons, particularly these kind of tort cases because of governmental immunity or just kind of the hurdles you have to get over to hold a governmental actor like this liable in tort, which is the fancy way we say, a civil wrong in the law.
Yeah. Right.
But like, in this case, I think the standard was like gross negligence, which is basically like a reckless disregard or a wanton disregard for student safety. And so like, in order to clear that bar, it's got to be really clear that like what you knew was enough to make somebody do something different than what you did.
Yeah.
And it's a high bar. Like,
I think we have those, we have those high bars. And I think that it's been I think that courts have made it very clear that as 2 things, that as long as educators, as long as the people who work in these schools act in good faith and are not grossly negligent, right? Like you do the best you possibly can, you act on the information that you are given, that you will generally be protected.
Right.
And the other thing is like courts have given educators over the last 20 years or so, since these safety issues have become much more front and center, courts have given schools much more deference to protect the safety and the well-being of students. So if you get information that you need to act on it, and generally you will be protected.
Right. And that's such an important point. Yeah.
Yeah.
School safety looms so large that we've kind of really give a ton of deference to educators when it comes to protecting student safety.
Right. Yeah. So, and we see it a lot in search cases, right? We see that deference when it comes to safety. We see that a lot. Right.
Yeah. And searches is something that's looming large in the background of a lot of these things. So like,
it's like I get information. AP, what do I do with it? Right. I'm going to have to look
here. Could have searched this child. And I think at some point someone actually did search the child's backpack, but like someone else said they saw the child take something out of his backpack and put it somewhere else.
Yeah.
And the AP, apparently dismissed that statement. So like there's so many different pieces of this that all play into it. But like you said, Jamie, those concerns, like school safety is so paramount that courts have been really deferential to actions taken by school leaders in pursuit of safety.
Right. So in this particular case, the court essentially said you had a lot of information that you didn't do enough with here.
Right.
With respect to the AP. And this whole case was just a sad, sad mess. The mom was also sentenced to, I think, 4 years in prison for child neglect and gun charges and things like that. Right. So like, it's just like, this is the kind of stuff. It just devastates families. It devastates communities. Like right.
And to think it was all done by a 6-year-old, like,
I know it's like, it's just it's sad.
It is. Yeah, and the criminal charges for the mom, like that's also something that's really interesting that we're going to talk about in just a second, because that's also something that's very, very new.
Very new. Like holding a parent accountable for the actions of their kid is a very new sort of legal standard.
Right. Well, it's they're being held accountable for their own actions.
Or their own actions that led to the actions.
Right.
Yes, excellent clarification. Thank you.
Well, just look at the lawyer if you want clarification.
Yeah. So that was our Bellringer. And while that case was more about like negligence, which is, as Chris mentioned, it's part of tort law. Our main case today deals with a constitutional legal issue. So an issue of whether or not someone's constitutionally protected rights were violated. So those are two very different sort of legal angles to look at a very similar situation from.
Right. And they overlap. So like you could bring both causes of action or both claims in a lawsuit, but they do have different legal standards. So we'll
basically. Yeah. So I think basically what's happening here is that we're going to assess the same situation. We're going to talk about the same situation, but we're going to use different lenses, right? To look at that same situation.
Right. To get a holistic picture of kind of the legal environment of these situations.
Exactly.
It's almost like we plan this stuff.
I know, right? Okay. So our main case today that we're going to talk about stems from a school shooting in Oxford, Michigan that took place on November 30th, 2021. So you'll probably, as we go through these details, you will probably recall this because it was also national news because the parents, got involved kind of legally or were made to get involved legally, which was the sort of unprecedented nature thing. That was one of the things that propelled this story into the national spotlight. So
I vividly remember this.
Yes.
I was practicing law in Ohio at this point. And like a lot of my school districts called us and were like, hey, like,
what's the deal?
What's the deal? Like, what do I need to be thinking about?
Yes. So we're going to talk about that case today. So, it's important we'll go into the details in a second, but, it's important to say that after this shooting, there was a flurry of novel legal actions, like we mentioned, and that was what made this particular situation kind of unique. So, like we said, the parents of the shooter, who was a 15-year-old student at the school, those parents were charged and convicted of involuntary manslaughter based on their, quote, gross negligence. So there's that term that popped up again. So the courts basically said, it's similar to the Virginia case, that the parents were negligent and their actions contributed to the student carrying out their actions. All right?
Right.
Prosecutors argued that the parents were partially responsible for what happened due to their enabling of their son and failing to intervene. They argued that the parents were negligent in ignoring their son's deteriorating mental health. They were negligent by buying him a gun. They were negligent by failing to secure the gun. And from failing to inform their son's school that he had access to a gun. Okay.
Yeah. And the parents got, I think, 10 to 15 years each for these. Yeah. Yes. So like, the Virginia case, that was a civil case. So we're just talking about like monetary damages. Like this is a criminal case. So we're talking about jail time, right?
Well, and the mom in the Virginia case also got jail time for negligence.
That's right. And the AP, I think their criminal trial is coming up this month. So like, there's a lot there too.
There's a lot of similarities. There's criminal negligence in both cases, but this Michigan case is also dealing with this constitutional issue. Now, it's important to point out here that this case, this Michigan case, this was the first time in U.S. history that a parent was held criminally responsible for a mass shooting committed by their child.
Wow.
First time.
And that's huge because like,
that's big.
That's one of the things that always comes up in these school shootings is where did the student get access to the firearm? Right. And also like,
because in most places you can't be a 15-year-old kid and walk into a store and just buy it.
Right. particularly the kinds of guns that are used in these shootings, right?
Right. Yes.
And then the other question is like, where along the like process or the sequence of events, like where people could have intervened to prevent this thing from happening, to prevent the student from doing what they did, like who was involved in that and where could they have like intervened to stop this from getting to where it ended up getting, right?
Right.
And I think that's part of the criminal case against the parents, right?
Yeah. And but not just, against the parents, what you're mentioning, this case sparked a whole bunch of lawsuits, right?
It did.
In addition to the one that we're talking about today. So lawsuits that, relied on a whole bunch of different legal theories and in a whole number of courts, looking to hold the school responsible, school personnel responsible, even law enforcement partially responsible. And we've seen that in a number of cases, Uvalde and whatever.
Uvalde. Mm-hmm.
Is like, let's talk about the role that law enforcement plays in all of this. So there's like a flurry of legal activity around these cases that cover a whole bunch of different angles. So, like you said, most of those cases are civil cases. And we're mostly talking, like you said, about monetary damages. But now we're starting to see a lot of jail time pop up with this. Michigan, Virginia.
Yeah. Mm-hmm.
So, it's there's a lot of newness with all of this.
Right.
And it creates a lot of interesting things to think about and potential implications for things like how schools should prepare for and respond to potential threats of school violence. So, given that whole setup, let's talk about the facts in this particular case. Okay. So like we said, November 30th, 2021, we've got a 15-year-old student. The student we will name EC. Well, we won't name him. The court names EC, and EC took a gun to school and used it to shoot 10 students and 1 teacher. 4 students tragically lost their life in this shooting.
Right.
Yeah. So this was an act. It was a culmination of events that began in early November that year. As we talk about this, I think it's really important to keep in mind who knew what and when. Okay, because these are the questions that the courts wrestle with, right? Hindsight. We've talked about this on the show before. Hindsight is 20/20, and people in the moment can only go off of what they know when they know it.
Right. Yeah. If these folks had a time machine, I imagine they would do something very, very different.
Very important to reinforce here. None of the players here is safe to say would ever want an outcome like this and never want their actions to contribute to an outcome like this.
Right.
So yeah, if people had a do-over, they would do it. So in early November, a student, not EC, some other student, found a severed bird's head in a jar in a school bathroom.
Wow.
Yeah, that's
not where I expected the story to start.
I know that seems like a significant escalation.
Right.
But no, this is the starting point. A student found a severed bird's head in a jar in a school bathroom. It was later revealed through EC's journal that he had killed the bird and brought it to school in the jar. Though at the time, school officials didn't know who was responsible. Okay?
Right. Yeah. So it makes me wonder like what they did to investigate that, but like also EC bringing that to school, like there's something there.
Something's
right?
going on. Yeah.
Yeah.
So about the same time, EC's Spanish teacher told a school counselor that EC seemed sad. That was the quote, the word that they used. The counselor offered to talk to EC, but EC declined. Okay. The weekend before the shooting, EC's mother posted a picture of him at a shooting range with a 9mm semi-automatic handgun, which the post said was, quote, his new Christmas present, unquote. School officials were not aware of this post.
Right.
Okay. So, again, hindsight is 20/20. You're listening to this and you're like, oh man, red flag, but school officials didn't know that post. School officials didn't know that EC was the one responsible for killing that bird and bringing it to school. All that school officials knew was that there was a kid who a teacher said seemed sad. Counselor said, "You want to talk?" Kid said no.
Right.
Okay.
Yeah. Yeah. And I think this is like, you can start to see the case against the parents starting to form, right?
Mm-hmm. Like clearly there is a kid
Mm-hmm.
who could have had some issues.
Right.
And had access to some dangerous stuff.
Brand new access. Cause I think like they bought him
This new
the
Christmas
firearm
present.
4 days before all of this went down or something like that.
Yeah. Now the shooting
but this-
occurred. Yeah. Go ahead.
Oh, the social media post I think is really interesting here because, like, you know, we've seen schools kind of like require students to give them their handles and like to follow them on social media so that like, and there's applications and AI bots and all that stuff that will like track the school community's social media usage to look for stuff like this. And like, you know, I think you and I have kind of talked about how, you know, those are potentially really kind of like challenging invasions of privacy depending on how they're done and like what tools you use and things like that. But like this, I think is a great example of like why that stuff
exists.
Why school leaders why it exists.
People consider it. Yeah. Why people consider using it. And absolutely. Okay. So the social media post was over the weekend and Monday comes around, which is the day before the shooting. And an English teacher saw EC looking at photos of bullets on his phone. The teacher reported this to the same school counselor who asked EC about the photos. EC said that guns were a family hobby, not necessarily any kind of abnormal thing in many parts of this country. Right. And in many communities, you know, hunting and all kinds of things, like, as we all know, this is just a part of our culture, our society.
Right. But a picture is starting to form here where like now we've got multiple touch points.
Right. Right. Okay. So that night, Monday night, EC wrote in his journal, quote, "The shooting is tomorrow. I have access to the gun and ammo," unquote. On Twitter, he posted, quote, "Now I am become death, the destroyer of worlds. See you tomorrow, Oxford," unquote.
Wow.
He had clearly decided on what he was going to do, and he is sharing it privately and publicly.
Right. Which, like, there's so many opportunities for somebody to step in and stop him.
Yep. But school officials were not aware of that posting. Like, again, you know, they probably did not have those search systems, those AI bots and things like that in place. There was nothing that presented that Twitter thing to the school.
Yeah, we don't know how many followers he had, whether or not anyone from the school community followed him, and whether they could have given that to the school officials.
We have no idea. Yeah.
Right.
So on the day of the shooting, another teacher saw EC looking at his phone and watching videos of shootings. The teacher reported this to the counselor as well.
And this was the day of.
This is the day of.
Okay.
So the counselor knew that this is like, I don't know what, the third time the counselor has been informed that.
Third time from 3 different teachers.
From 3 different teachers. Okay. About a half an hour after that, a math teacher found one of EC's worksheets. And on that worksheet, EC had sketched a pistol, a person with gunshot wounds, and a bullet. He had also written on the worksheet, quote, "Blood everywhere," unquote, quote, "My life is useless," unquote, and quote, "The thoughts won't stop, help me," unquote.
Wow.
Okay. The math teacher immediately alerted the dean of students about the worksheet. Within minutes, the counselor escorted EC to the counseling office, and the dean of students retrieved EC's backpack from the classroom. Okay, so it sounds like at this point, everybody is like, let's move.
Right. Yeah. Within minutes, right? So
within minutes. Yeah. Okay. So once in the office, the counselor and dean asked EC about the drawings. EC claimed that he was drawing characters from a video game. The counselor responded that this does not sound like a video game.
Yeah.
When asked whether he was a threat to himself, EC responded, quote, "I can see why this looks bad. I'm not going to do anything," unquote.
Which implies that he'd been thinking about like
how this looks. And
right.
Yeah.
And that like he's considering doing something. Like the fact that you have to say, I'm not going to do anything means you've thought about it.
I mean, or you think that other people
right.
think you're going to do it. So I'm going to give them the answer that I think they want to hear.
Right.
The counselor then called EC's parents and told them that they needed to come to school. He said he was worried that EC was suicidal.
Yeah.
Okay. So that was their take on it. They called the parents and they said, "We need you to come get him." Okay. EC's parents arrived around 10:30. The counselor told them that EC needed immediate counseling that day, if possible. EC's parents responded that that wasn't possible because they had to go back to work. The counselor then told EC and his parents that if they didn't get him counseling within 48 hours, that they would call Child Protective Services.
On the parents?
On the parents. The meeting ended when EC's mother asked, "Are we done?" And the parents just left.
Ooh.
Yeah. So it sounds like they were saying, okay, we are recognizing that we've got a disturbed kid here and that, and we think that there is a immediacy to
there's urgency here.
Urgency to intervention of some sort. Okay. Now, at no time during the meeting did the counselor or the dean search EC's backpack. Okay.
Right.
That's important to mention. If they had, they would have found the 9mm semi-automatic handgun that he had brought from home. The same gun that his mother had called his new Christmas present. And that would have been a whole different can of worms because bringing a gun onto campus and all of that, would have been, he would have been gone and not allowed back for probably a little while.
Right. And I think at this point, we've talked about search and seizure in schools, to accord with the Fourth Amendment's prohibition on unreasonable searches and seizures, the search by school officials has to be justified at its inception, has to be reasonably related in scope to the circumstances justifying the search. I think you've got enough here, justified at its inception. You know that you've got these drawings, you've got the videos, you've got
a kid who seems obsessed with, or not obsessed, but you've got a kid who seems very fixated on violence and guns.
Right.
Okay. Now, keep in mind, they didn't know about the parents' social media post. They didn't know about the kids' social media post at this point.
Right. They didn't know he had access to the firearm because the parents didn't say it, which is part of the case against them, right?
Correct. Yes. No one mentioned that. They just know that this is a kid who has been acting differently at school and has been seen to be very interested in violence and guns.
Right. And so there's a potential scope issue.
Yeah. But I think that like what we said before, schools have provided a significant amount of deference, or courts have provided a significant amount of deference to schools when it comes to school shooting kinds of things,
Right.
And
because
so
the intrusiveness is directly proportional to the thing you're looking for. So if you're looking for something like, a weapon,
something that could
then
cause
you can have a more intrusive search, right?
Exactly.
And searching a backpack isn't
not
intrusive.
that intrusive. No.
Right.
And
so that's an option here.
Now we can only speculate, but I would say, given what we know, if they had conducted a search, I wouldn't and they found a gun or whatever. I don't
It'd be
necessarily
tough to find that unconstitutional.
Yeah, I completely
even if they
agree.
didn't find, put aside what they find or not.
Yes. Even if they didn't find a gun. Yeah.
Right. You could also involve law enforcement at this stage. And there's every state has procedures for Baker acting or pink slipping an individual who might be a threat to themselves or others.
Right.
So involuntary hospitalization, things like that. But it sounds like the parents might not have been full participants with the school's concerns at this point.
It doesn't sound like it at all. It sounded like they were offended, might not be the right word, but, off put by being called in there in the first place. Anyway, so here's what happened. So after that meeting, because the parents had to go to work and, said, and the school said what they said, like, we feel like you need to come
gave
get
you a
them.
deadline, right?
You've got, and if you can't do it today, it needs to be done in 48 hours or we're going to call child services. And the parents were like, are we done? I'm out. And they left.
Mm-hmm. Right.
So EC goes back to class. All right. And he goes over the next 2 hours, went to all of his classes, no other information, came to light, came to anybody's attention. And around noon, so about an hour and a half after this, he left class, went to the bathroom. He took out the gun from his backpack and then came into the hallway and started shooting. So that's how it went down.
Oh my gosh.
So what happened, Chris? So how did all of this play out in the courts? So we already said that the parents were found negligent, and definitely contributed to the actions of their kid. And yeah. So how did everything kind of play out?
Right. Yeah. And so we're just looking at kind of the legal aftermath of, this tragedy. And I think like that's an important kind of thing to recognize, because like the law is just one piece of all of this, but it's an important piece. And, it's one that obviously is the focus of this show. But so many of these things are not legal problems or not legal challenges. Right. But the law can hopefully give us frameworks or help shape our actions to hopefully address some of these concerns moving forward, or to make sure things like this don't happen again. Right.
Yep.
So, after this, we had the immediate criminal prosecution of both EC, who was sentenced to life in prison without the possibility of parole, which is Michigan's harshest criminal penalty. Mm-hmm. Both parents were each sentenced to 10 to 15 years for involuntary manslaughter because of their gross negligence in failing to address this and, getting him the gun and all of the things that they did. The victims of the shooting and their families also brought a number of civil lawsuits seeking recovery against the school and law enforcement personnel on various theories of tort liability. So we talked about this with the Bellringer, but those cases can be really tricky because of governmental tort immunity and other issues about like holding a third party responsible for the acts of another person. So, holding the school accountable for the acts of EC. So there was one state law tort case that was filed by the victims here that was dismissed because of that higher bar for these sorts of tort cases against governmental actors. Right. So a Michigan appellate court affirmed that the school officials here, the counselor and the dean of students, did not act with, quote, gross negligence, which Michigan defines as, quote, reckless disregard for whether an injury results. So that's that heightened standard. So it's not just standard negligence. It's got to be gross negligence. And for the Michigan appellate court, that the school officials' actions didn't meet that standard. So they dismissed the case. There are some other cases that are still ongoing, though. And, the case we're talking about today is a little bit different because it's not a tort case. As we mentioned, it's a federal constitutional case. So some of the victims brought this lawsuit in federal court. So those tort cases are typically done in state court because torts are state law. This is the United States Constitution, and the victims here were arguing that the school essentially violated their due process rights under the 14th Amendment by contributing to the danger that they were in.
Wow.
In this shooting.
That's interesting.
Yeah.
Substantive due process. And we've talked about that on this show before. That's a hard one.
It is. It's hard to say, and it's also hard to understand.
Yes. Yeah.
So, the due process clause says that nobody can be deprived of life, liberty, or property without due process of law. And so, there's
two
this
buckets,
idea of
right? There's two buckets,
procedural and substantive.
Yeah.
And the deprivation of life, that's kind of what happened here, right? That's what we're talking about.
Right.
And so the argument is essentially that while, the Supreme Court of the United States has not really used the due process clause to guarantee a certain level of safety or security from the government. So the government, it doesn't bind the government to create a sort of amount, some specified level of safety or security. But there are very kind of specific circumstances where it might be implicated based on what the government does to contribute to the danger. So there's this doctrine called the state-created dangers doctrine. And this is situations where state officials take an affirmative action that actually creates or at least increases the risk that someone will be harmed by a third party. So it's basically where the government either contributes or like causes the thing to happen, even though it's a third party ultimately doing the bad thing.
Okay.
And that's what's happening here. So like it has to be, and there's a couple elements of the state created dangers doctrine that you have to meet. The risk has to be particular to a specific potential victim. It has to not be some general danger to the public. It has to be individualized or particularized. And the state officials' actions have to be, and we've talked about this one before, so egregious, so outrageous that it may be fairly said to shock the conscience. So that's kind of the thing. Like basically the government did something so outrageous that they put you in harm's way. Yeah. And by doing so, they should be responsible for the harm, even if the harm was caused by somebody else.
So basically in this particular situation, what the question that they want us to look at is, were the actions of the school, the counselor, the dean of students, bringing the parents in, like, could somebody look at all that, given the information that they had at the time, and say, holy crap, you guys didn't do more? Yeah. Like that's kind of what they're, they're going for, right?
That was the perfect way to say that without any legal jargon. Holy crap.
Yeah, no, well, but like, again, like the legal jargon about, shocking the conscience and
right.
Like I'm just trying to figure out a different way to kind of illustrate that legal standard. And,
right. Yeah. And I think that's exactly right. Someone looks at that and their jaw hits the floor.
Now, I mean, I guess, even though this was not the same legal lens that was used to look at the Virginia case, right? And it's a little bit of a different bucket. You could look at the Virginia case, for example, with all of the information that was made available to the AP, and potentially have a holy crap, you didn't do more kind of response to that. And so anyway.
Yeah. And that's one of the things that's interesting between these tort claims and these constitutional claims. So the tort claims is looking at acts and omissions. So things that you did or didn't do.
Yeah.
The state created danger is only about what the government did.
Oh.
So it's not a question of like, did you not do enough? It's a question of like, did you take affirmative acts to
did you
create
do stuff
or exacerbate?
And was that stuff reasonable?
Right.
Yeah.
Yeah.
Or did you do something that caused the thing to happen?
Right. Yeah. And so the plaintiffs here are pointing to three things that the school did, that school officials did, either the counselor or the dean of students. They're pointing at three things that they say rise to the level of egregious and conscious shocking behavior. The first one is that the plaintiffs argue that the counselor and dean created the danger when they gave EC his backpack back, and sent him to class.
Okay.
Because he didn't have it, which means he didn't have access to the firearm, and then the school gave it back to him. Ostensibly without searching for it. And the court rejects that argument.
Okay.
Because essentially they say the state action here kind of put everyone in the same position they were in before. Before this all happened, EC had the backpack with the gun in it. Yeah. After all this happened, EC had the backpack with the gun in it. So it's kind of the governmental actors here didn't add to the
change
danger.
Anything. Yeah.
Right. Exactly.
Didn't change anything. Yeah.
And so, no one's claiming that the school officials had any idea about what was in the backpack when they gave it to him or anything like that. So the court rejects that argument.
Okay.
So the next argument that the plaintiffs make is that the counselor and dean created the danger when they concealed from other school officials the risk that EC might shoot other students in the school.
What? Wait.
And that's a tricky one because it's an omission, right?
Yeah.
Failing to warn is an omission. Concealing is an active action. that's kind of the distinction here that the court draws, right? Like,
but I didn't see any. I didn't see much evidence that they had
anticipated
that
he was
they
a harm to
anticipated a
others.
shooting.
Right. Yeah. Yeah. Because they were talking about whether or not he was a threat to himself.
Yeah, and again,
Yeah.
like they didn't know he had a gun. They just knew that
Right.
he had this kind of fixation on violence and ammunition or whatever and shootings. They didn't know they didn't have any evidence to assume that this kid was actually carrying a gun with him.
Right. Right.
Like
Yeah.
there's a lot of kids who like violent video games and things like that. I mean, you know, it is what I'm not trying to make excuses or anything like that, but
Right.
I'm just trying to go back to what we said at the beginning of the episode about who knew what when.
Exactly. Right. And
Right.
the court, you know, embraces a lot of those arguments and kind of says like, you know,
They didn't know enough to be screwing up in their actions.
pretty like, I mean, that's kind of
That
the
was
gist of a lot of this, right? Like
It's a very
their-
poor
their
way to say
conduct-
it, but yeah.
Yeah, their conduct doesn't rise to that grossly negligent
yeah.
or like outrageousness that's required for this.
Yeah.
But yeah, so for the court, like there's no evidence here that the school officials concealed anything. Like,
Yeah,
you know,
because they didn't know.
Right, exactly. They didn't know.
Yeah.
So there's nothing,
Yeah.
they didn't take affirmative actions to like conceal something. They just didn't go further with what they did know.
Right.
Right.
All right. So what's the third thing?
So the third thing, and this is the one like the trial court. So we're at the appellate court level at the Sixth Circuit. The trial court actually said that this one was plausible. This one like could have been enough to survive the preliminary motion to get rid of the case or decide the case.
Okay.
And so this one is based on the affirmative act of the counselor's warning to EC's parents that he would call Child Protective Services in 48 hours if they didn't get EC counseling.
So basically what we're saying here is the school or the counselor thought that something was serious enough that could warrant a call to Child Protective Services. So there's sort of
Why
an
did you put a
acknowledgement.
48 hour?
Why? Yeah. If there was something serious that warranted a call to Child Protective Services, why'd you wait? Why? Like if it rose to that level, why'd you just let them go back to class?
Right. And the constitutional aspect of that is by making that warning, the plaintiffs here are arguing you actually increased the risk that this student who was exhibiting some signs of mental instability would harm other students, because now that student feels like, oh, I've got a 48-hour window to act. So like that's the argument. The argument here is like by saying that you actually ramped up the danger a little bit.
Okay. I can see that. I can see.
And that's what the
point.
trial court said, right? They said, I can see that.
Yeah.
The appellate court, though, comes out the other way.
Oh, interesting.
Because they focus on whether or not the action was so outrageous as to violate due process. So they're putting aside that question of like whether or not it contributed to the danger and just looking at that egregiousness aspect of it.
Yeah.
And they kind of say like the government's actions here, the counselor and the dean of students, at one point they say like this was anything but outrageous, because as soon as they knew they obviously clearly perceived a potential serious risk, they immediately called the parents.
They tried.
Insist that he get counseling.
Yeah.
They give this deadline. Like this is the opposite of callous indifference.
Yes. Yes.
Right. And so like the threat of calling CPS was like intended to get EC help.
Yes.
And so much of this is that question of hindsight. Like, if we knew what they knew, would we do something differently? If we knew what we know now, would we do something differently? And I think like, you put a dozen different people in that chair at that time and you'll get a dozen different courses of action. Right.
Totally.
And that's why the law is so kind of not deferential, but like why it has such high standards here, because it wants to accommodate different approaches.
Sure.
And so, all of that to say is the court comes at this and says like, it wasn't conscious shocking in the constitutional sense. And so therefore there's no constitutional violation here.
Yeah. Wow. I mean, okay. So it looks like what we're seeing here is in many cases, like from the constitutional perspective, not a lot necessarily to, it's hard to get schools and school personnel on the hook
for something like this.
Something like this, from a constitutional perspective, from a tort perspective, from a negligence perspective. That's a different story that we are seeing emerge in the courts in terms of holding grossly negligent behavior for both parents and school officials. Right. And, with this Michigan case, first time we're seeing parents held criminally liable for contributing to the actions of their kid. So the takeaways, like, what do we take away from all this? I mean,
this stuff is hard.
Yeah. I mean, it's hard. It's sad. It chokes me up. Like, I remember I was sitting in my office as a principal the morning of the Sandy Hook massacre.
Oh, yeah.
And I just, it was one of those kind of, major 9/11 kind of moments where, like, you ask somebody somebody will tell you exactly where they were, what they were doing, what they were wearing, what they were looking like. Those kinds of moments leave such a mark on your memory, on your psyche or whatever. I remember where I was, and I remember sticking my head in my hands. Like these things are, you can't even describe how terrible they are and what it does to parents, to a family, to a school, to a community. Like there's just so much to these complex situations. There's so many perspectives. There's so many voices. There's so much noise. And at the end of the day, we're talking about keeping kids safe.
Right.
To kids and teachers and, everybody. So what are the takeaways here? Act reasonably, right?
Yeah.
Like I know it's kind of silly to say that. It comes, that's kind of something that we say often on this show. Like, okay, what do we need to do moving forward? What are our big takeaways? Don't do nothing, right? Act reasonably. Courts, like we have said over and over again on this episode, courts generally provide a lot of deference to schools. Just don't be stupid. Don't do nothing.
Right.
Right?
Right. And the flip side of that is know your law, know your policies, so that you know what you can do when and how. Because I think so many school leaders, like, sometimes the law can be paralyzing, right? Because like, you don't want to make a misstep. But when you put on the other side of that balance student safety and concerns, like, then I don't want the law to be an impediment to, like, make you not do something you otherwise can do under the law, because folks didn't know where those lines were. And like, that's what that's one of my greatest fears is, like, I really value student rights, and like, student rights are very much implicated in all of this. Right. But like, it's that question of, like, where are the lines? When can you do what you need to do in order to accomplish multiple goals? Right. And like, I think with something like this, like, that is such a powerful lesson here. Yeah.
Well said. Well said. All right, sir. What would you say is our homework for this week?
That's a tough one. Yeah.
Let's like, rate, review, Chalk and Gavel.
Keep it simple. Yeah.
Keep it simple. Check out our website. Order some merch. Help support the show.
Go find some joy. Order our merch.
Yeah, exactly. And give those kiddos a big hug. That's your homework.
Here.
All right. Okay, everybody. Have a good one, and we will see you again in 2 weeks.